Are you looking to change a portion of your divorce or custody judgment and you don't know where to begin? I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to explain how to file a motion to modify in Connecticut Family Court. Now, a motion to modify is a request to the court to change an existing order. It's different from an appeal, which is an appeal to a higher court where you're essentially saying that the original judge made a mistake. With a motion to modify, you're not saying the judge made a mistake, you're simply saying that the circumstances of your family have changed, which make a modification of the existing orders appropriate. Now, the types of things you can modify in Connecticut Family Court are legal custody and the parenting plan, child support, and alimony, so long as the alimony is not specifically outlined as non-modifiable. What you cannot modify in Connecticut Family Court are property settlements. So the orders with regard to division of assets such as real estate, bank accounts, and retirement accounts, or the division of debts, those cannot be modified as they are final property settlements. Now, to succeed on a motion to modify, you don't only have to show that there's been a change in circumstances, you also have to show that the change in circumstance warrants a modification of the existing orders. Now, examples of orders that might be modified are an existing alimony or child support order based on the fact that the person who's paying the support lost their job. Or maybe the person who's paying support is earning more money and the person receiving child support wants more child support. In that circumstance, the modification would potentially be appropriate. Or if a parent's work schedule has changed and the existing parenting plan is unworkable, that could be a basis to modify an order. Or if a child's needs have changed so that the existing parenting plan is no longer in that child's best interest, a modification of the orders can be appropriate. Now, to locate the actual motion for modification form, you should do a Google search for JD-FM-174, and you should find this form. To fill it out, you first check off the box for before judgment or after judgment. If this is a case where the initial case was filed and that initial case has still not been finalized, maybe there are some temporary orders in place, then you check off the before judgment box. But if there is already a final custody or divorce order, then you click the after judgment box. And then you fill out the section below. So the judicial district where your case is heard, the town where that judicial district is located, the docket number of your case, the names and addresses of both parties, and then you put your name in this box and check off whether you are the plaintiff or the defendant. If you're seeking a modification of child support, you check off this first box, you put in the date of the existing order and what the order states with regard to child support. You check off whether you're seeking an increase or decrease of child support and any other remedy that you are seeking. If you're seeking a modification of alimony, you do the same thing, the date of the existing order, what the existing order states, and whether you're seeking an increase or decrease. If you are seeking a modification of the custody orders, you put the date of the existing order, what the order states, and what you are asking the court to change the order to. And that's the same with visitation. As far as any other modifications, if they don't fall into the categories above, you check off this last box, enter what the existing order states, and what you are asking the court to modify the orders to. You then go to the second page and again put in both parties' names and the docket number and check off the first box that there has been a substantial change in circumstance since that existing order which you described above was entered. And then in the box below you explain how there has been a substantial change in circumstance and why you are asking for the orders that you are asking for. Finally, you check off whether or not either party has received state or Husky assistance, and you sign the form, print your name, put your date, email address, other contact information, etc. You then fill out the certification page by putting the date that you're filing the motion and the names and addresses of any parties to the case. Finally, you sign the form, print your name, and date it. You will then bring this form to the clerk's office of the courthouse where you are filing it. And keep in mind, there is a $180 filing fee associated with the submission of this form. So unless that fee is waived, you have to pay that fee. If you want to seek a waiver of the fee, you can ask the clerk for a fee waiver form and submit that to the clerk, and the judge will rule on it. Now, this third page you do not have to fill out. After you submit the motion to modify, the clerk will fill this out with the relevant court date information. Now, once you receive the paperwork back from the clerk, you then have to arrange for the other party to be served by a marshal. Unless it's a pre-judgment motion, in which case you do not have to have the other party served, you can just mail or email them a copy. But the clerk should be able to give you a list of marshals, and you have to choose a marshal who works in the county where the other party is being served. And you have them do it. The fee is usually between $50 and $100, and they will serve the party and then provide you with a return of service form, which you have to submit to the court. Once the other party is served and you file the return of service, you'll then go to court on the assigned date, and you will meet with family relations first with the opposing party to try to reach an agreement. But if you're unable to reach an agreement, then you will have to have a hearing in front of a judge, and a judge will make a decision. So those are the basics on how to file a motion to modify in Connecticut Family Court. As usual, if you have any questions, you can contact our office. And if you are looking for representation in a divorce or family law case here in Connecticut, we would invite you to contact our office as well.